you were charged with Penal Code section 273.5a. That's corporal injury to a spouse or cohabitant. It can be charged as a felony or a misdemeanor in California, and it's basically just a domestic violence charge where they're alleging that there was an injury. One of the things that you may be wondering, and that you should be wondering actually, from the very beginning, before you even go to your first court date, is what happens if you lose at trial. And in this video, I'm going to be explaining exactly that. My name is Veronica. I'm a domestic violence defense attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. And again, in this video, I'm going to be talking about what happens if you lose your domestic violence case at trial. Does it mean that you go into custody immediately, into jail? Does it mean that you get the max? Like what actually happens? Do you have any leverage? Is there anything that you can do at that point? So the jury comes back with a verdict of guilty. 12 people have agreed that you are guilty. What happens next? What happens next is that typically the case is going to be set for a sentencing hearing. Because after you lose at jury trial, after you've been convicted by the jury, the judge has to sentence you, but there's still this sentencing hearing. Now, immediately after the verdict, assuming that you are out on bond, you are not in jail, the judge could potentially decide to take you into jail, into custody. They usually won't, it really depends. For the Danny Masterson case where there was a verdict against him recently, he was out on bail and the judge immediately took him into custody because she found that once he had been convicted of these offenses where he was facing 50 to life, he was a flight risk. And I mean, honestly, he probably was, right? Anybody in that situation, if you can go ahead to a country where there's no extradition, you're going. The judge will look at other factors, like if you are a danger to the community, and they've now seen more evidence against you, so they may find that you're a danger to the community, but typically, your bond will not change. Usually it won't, and the case is just set for another hearing date where you would need to come back. Now, at that sentencing hearing, the judge still has to decide what your sentence will be. So you've been convicted, but they still have to decide on the punishment. What is it going to be? Now, if you were convicted of PC 273.5a, maybe it was a felony this whole time, but at the time of sentencing, the judge can reduce it to a misdemeanor. So, the judge hears the conduct, hears the extent of injuries, and thinks this is not really a case that should rise to the level of a felony, and reduces it at the time of sentencing. At the sentencing hearing, the defense can present good things about you. So your own lawyer can present good things about you, hardships you've experienced, have people talk on your behalf, and the prosecution can present bad things about you. The alleged victim can also make a victim impact statement in which they talk about how horrible this was for them, and in that victim impact statement, sometimes they ask the judge to give you a certain sentence or give you the max. If it's not clear already, losing at trial does not mean that you will get the max, right? There's still the sentencing hearing. There's the option for it to be reduced. Your defense attorney can still put on evidence on your behalf. The prosecution puts on evidence on their behalf. But keep in mind that the judge might be harsher and likely whatever you do end up with, likely, but not for sure, will end up as a worse sentence than whatever you were offered before trial, and that is for a few reasons. Number one, before trial, you have some leverage because the prosecution does not have a conviction yet. And so when they are making an offer to you, they are figuring, well, there is always the chance that we lose. That's always going to be factored in. Now, they have won, and so you lose that leverage. There's no question as to the result of the trial. Number two, the judge has now heard a lot of bad things about you, things that the jury felt were bad enough to convict you. And so that can make the judge more likely to want to give you a worse sentence than a prosecutor who simply read the police report, sort of skimmed it over and not paid all that much attention to it. Number three, when the victim makes this victim impact statement, and they're more likely to be present, by the way, if you had a trial because they probably had to come and testify. They're going to be emotional, and now the judge sees there's this person who really wants them to do something. And so the judge is going to be more likely, if the victim is saying, I want this person to go to jail or prison for what they did, they're more likely to do it than perhaps a prosecutor negotiating with your defense attorney who's never even seen the victim. Number four, the judge is likely annoyed that you wasted the court's time at this point, or at least might be annoyed that you wasted the court's time, that you made his or her days longer because you were too stubborn to plead guilty and you got convicted anyway. So this is known as the trial tax. Basically, that if you go to trial, you don't take your deal in a criminal case and you lose, you get this trial tax. Now you've shown that even though you were guilty and now you're legally guilty, you refuse to cooperate, you refuse to make any deal because you were just that stubborn. And so now you've wasted a ton of the county resources, you've wasted a ton of jurors' time, a ton of the court's time, and for what? You were guilty anyway. That's basically how they look at it. It doesn't mean they're going to get the max, but it's a factor that works potentially against you. Now, what can they sentence you to? So if we are talking about just PC 273.5A, if it's a misdemeanor, up to a year in jail and up to 3 years of probation. Now keep in mind that you cannot generally expunge a conviction until you are off of probation. So that's 3 years that you have this on your record. And for a felony, as long as you don't have any priors, it's up to 4 years in state prison. Now, most people with no priors are not going to get 4 years in state prison, but there are certain factors that could cause you to potentially get that, especially if there was a really bad injury in this case. So I say all this not to scare you. In fact, a lot of people think that if you go to trial and you lose, you get the max, and that's not true. So I want to dispel that notion and show that there is still hope there, while still making sure that you have all the information as to what's going to happen. If you get an offer of probation before trial, it's not a certainty that the judge will give you probation if you lose the trial. The more information that you have ahead of time when you're figuring out how to make these decisions. I hope you found this video helpful. If you did, please don't forget to like, subscribe, and ring the bell.